I'm just reading this response from the state's response. Yes, page 2. Yeah. The defendant has had significant time to seek a remedy in regards to the order for protection. Section 9 of the order for protection specifically allows the defendant to seek review of the order upon motion at any time in Clallam County Superior Court. Now, the state's response is that I've had significant time, about 6 years. The first protection order was issued in July 8th of 2011, and there was no possible way that I could have responded. Now, I know that the state could actually enforce the laws without me having to motion the Superior Court of Clallam County. I have in a number of emails mentioned to remove the protection order because there is no jurisdiction for me to motion the court. Now, when you actually look at this protection order, the court has jurisdictions over the parties, the minors, and the subject matter. Respondent had reasonable notice and opportunity to be heard. Notice of this hearing was served on the respondent. Personal service? No. Service by mail? No. Service by publication? No. Respondent received actual notice of the hearing. I did not receive actual notice of the hearing. Now, as it says here, significant time specifically allows the defendant to seek review. I cannot motion a court where there was no jurisdiction because I was not given actual notice of the court hearing. Now, the state would say, well, if you don't like it, motion the court. And I would say, if I were to motion a court without jurisdiction, I would be committing a crime. Now, I'm not an attorney, okay, but it seems to me that if I wanted the court to review the protection order's provision of section number 9, I would need to be given actual notice and opportunity to be heard before it is issued. Now, if you had done what the law requires, then section number 9 would be applicable. But when the court decided to commit domestic violence against the rights of America's citizens because they issued a protection order without giving me actual notice and opportunity to be heard, they violated all the laws. Now, this happened in 2011, the first temporary protection order, and then without any attempt of service because I was on Guam, the second temporary protection order because there was no attempt of service because I was on Guam. And then the issuance of a permanent protection order where there was no attempt of service because I was on Guam. Without a doubt, my conjugal rights have been violated. And somebody has been committing domestic violence against the laws of the United States. Now, as subversives to what the law requires, I'm not going to motion a court where there is no jurisdiction. And since you decided you were going to commit domestic violence against the laws and the authority of the United States of America, you are going to have to remove it.